Yes, ma'am.
Thank you, Rekha ma'am. Thank you, Sudesh sir, and thank you, Dr. Nikhil Datar sir, for an excellent discussion. I would now welcome Dr. Monica Singh madam to welcome our chairpersons for the next session. And over to you, ma'am.
Thank you, Dr. Sneha Bihar, madam. Thank you, Benchmark Series. And thank you, Monica Umbarden, for inviting me here. I'm sorry for the delay in joining. I was moderating a panel with BSc committee. So this is the last talk of the session by our esteemed speaker, Dr. Neeraj Nagpal sir, who is past president IMA Chandigarh State Branch. And we have the chairpersons for this session, Dr. Jamna Devi Gudi Devni. Madam is Senior Consultant OBGY at Yashoda Hospital, Sikandrabad, and a medical legal advisor. She has got many degrees
I
and lot
think
of
we can
accolades.
cut short,
And
Monica.
yes, ma'am. Yes, ma'am. And most importantly, chairperson of the State Medical Legal Committee currently. Welcome, Jamna Devi, ma'am, for chairing this session. I also would like to invite Dr. Gorak Mandrupsakar, sir, for chairing this session, who is Consultant Reproductive Medicine at MCHS Islampur and Director of Angel IVF Clinic, Pune. Next, I would like to invite our chairperson, Dr. Suman Sinha, madam. Can I have a CV? Yes. Dr. Suman Sinha, ma'am, is a very senior consultant and a chairperson of a general surgery committee of FOXY. And we invite her, president of Ranchi OBGY Society in 21 to 23. And we invite madam to chair this session. And I would also like to invite Dr. Meena Samant, madam, for chairing this session, who is a senior consultant in HOD at Kurji Hodi Family Hospital, Patna, Bihar, and President of Patna OBGY Society. Welcome, chairpersons, and over to you for introducing our speaker, Dr. Neeraj Nagpal, sir.
Can I take the honor of introducing Dr. Neeraj Nagpal?
Yes, ma'am.
Because I always look upon him and we listen to his talks and learn a lot. And he's the chairman and managing trustee, MLAG, ex-president IMA Chandigarh State Branch, director Hope Gastrointestinal Diagnostic Clinic, Chandigarh, and member of ASG, ESG, ISG, INASL, SGEI. And not only that, he's a fellow of International Medical Science Academy, Indian Society of Gastroenterology. And sir has done a lot of work on these issues, and he has been member of editorial boards and edited books, and a lot of chapters he has written, which I think all of us do read. And there are research papers in international and national journals. And sir, I think without much ado, I think we would like to listen to you and learn a lot.
Well, thank you so very much for the kind introduction. Am I audible?
Yes, sir.
Yes, sir.
Okay. There is some problem with my laptop. I don't know whether my presentation will run, but let's start. The topic given to me initially was, I think, slightly different from what I see in the program today. And the program says that I have to speak on Consumer Protection Act. So this is now nearly off the cuff. Consumer Protection Act has been bugging me for last more than 30 years. And we have tried to do what we could about it, as I will explain in my talks. But the fact remains, the problem lies with us doctors, because we do not seem to have still realized the magnitude of the problem. And it is only when we have a case filed against us that we feel temporarily upset. But time is coming when we all need to be together to take action in this matter, because this is going to change the face and the way we work in medicine. So there was a lot of confusion when CPA 1986 came in, and there were multiple judgments from various high courts where, like the National Consumer Dispute Redressal Commission in 92, in two separate cases where IMA also was party and Qualified Medical Practitioner Association was also party, they decided that medical services by hospitals and doctors were covered under CPA, and this was not a personal service. But then they had also decided that lawyers would be also consumers under the Act. Again, in 1992, in A.S. Chandra versus Union of India, Andhra Pradesh High Court said that the services which are provided by medical practitioners must be construed as service, and the persons who avail these services would automatically become consumers. A slightly different view was taken by Madras High Court in 94, where they said if a doctor or a hospital is doing diagnosis and treatment, that would not come within the definition of service, but paramedical services, if are being provided by an establishment, they would be covered under the definition of services within CPA 1986. So all these matters, they finally landed up with Supreme Court, and the Supreme Court bunched up in VP Shanta and others versus Indian Medical Association. And in 95, they gave a clear verdict that doctors and their services, hospital services, all were covered within the purview of Consumer Protection Act. But they had also said very clearly that only outright cases of negligence would be adjudicated in consumer courts. And where complicated medical issues were involved requiring evidence of experts, civil courts would be appropriate. So this escape mechanism, or this what should I call, escape, in fact, was given to the doctors so that this argument that judiciary had no knowledge of medicine and medicine is a complicated science and two doctors may not agree on one single path, and expecting a lay person to take a decision would be an injustice to doctors. So to cover themselves, they had put in this clause that it will be only outright cases of negligence which would be adjudicated in consumer courts. Then in 2002 came the judgment of J.J. Merchant versus Srinath Chaturvedi. And here now Supreme Court says, no. Even where complicated questions of facts are involved, requiring evidence of experts, consumer courts can still adjudicate in these matters. So the issue of only outright cases of negligence was removed, and where expert evidence was needed, even they were included. This was well seen in the Kunal Saha case, where on video conferencing, expert evidence was taken from US, from doctors. And that was the classical example, I think, of this. They also said very clearly that this thing, the judges have no medical knowledge, because repeatedly I hear people come up with this argument that a medical board should be there, a medical tribunal should be there. Mind you, this argument was already taken up in 95 by our advocates in Supreme Court, and they had said that consumer courts will be dealing with many areas of service. People will be who are providing electrical services will be covered, architects will be covered, everybody who is in any kind of service would be covered. And you cannot expect all services to start demanding that judges who have knowledge of their subject only should judge them. So effectively, this argument was overruled by IMA versus VP Shanta and others. Very good. Let's see this judgment of 2023. Aarti versus Dr. Gagandeep Goyal, National Consumer Dispute Redressal Commission, not a district forum, not a state commission. This is a National Consumer Dispute Redressal Commission judgment. What does it say? It says removal of gallbladder instead of conducting laparoscopic surgery to remove stones in the gallbladder without the consent of the complainant was incorrect and against medical ethics. And no case has been made out that the surgery was essential in life-threatening situation. Such exhaustive knowledge of the judiciary flabbergasts me, and this is the reason why we need medical tribunals. Problem is to convince the judiciary that sometimes, or a substantial number of times, they are talking through their hat, is inviting contempt and so everybody keeps quiet. Our main objection to Consumer Protection Act and medical services is that consumer courts are summary proceedings. You make a complaint, the person gives a reply, there are certain affidavits which are filed, no cross-examination, no investigation, no arguments. Based on the documents, the courts are expected to give decision in a summary fashion, in a fashion which prevents a very long dragging of cases. But yes, when we looked at Dr. Desai's case from Mumbai, Tata Memorial, it only took 26 years to get him a verdict that he was not guilty of negligence. So these kind of things, despite the language that this is a summary proceeding, and in summary proceedings, basically, the aim is to find an excuse how to compensate the consumer. The consumer has had a loss. How to compensate the consumer? Some excuse is to be found, whether you have not taken consent or your documentation is not correct or whatever the reason may be. It may not be relevant also to what has finally happened in the case. But some kind of excuse is found and some compensation is awarded because the sympathy of the courts is with the consumers. What is my problem with this? In 1995, I had published a compendium of CPA medical judgments. There were a total of 113 cases of medical negligence which had been adjudicated and decided by courts, including consumer courts, up till 1995. So there were some cases who were even before 1986 in civil courts. But out of these 113 cases, then we published the second volume in 2004, and there were a total of 270 odd cases between 1995 and 2004. This time, we took out the statistics from Confonet, and from 1st January 2023 till 31st December 2023, National Consumer Dispute Redressal Commission decided 261 cases of medical negligence. The 54 state commissions, including their circuit benches, decided 1,048 cases of medical negligence. There is no way to find out the exact number of cases decided by the district fora. So we had used a formula from one state. We took the example of Haryana. And in Haryana, in this period, the state commission had decided 10 cases. And all district commissions of Haryana had together decided 170 cases. So this was 17 times in the district compared to what was decided in the state. The same formula we used for the total number we had, and we got 17,816 cases decided by district commissions. Effectively, total number was 19,000 cases decided by consumer courts in 1 year. Now, we have to realize that for every judgment which is given, there are at least 2 cases which are pending in courts. And this is a very, very conservative estimate. That means 19,000 plus 38,000, which is around 57,000 cases, are decided or are pending at one point of time in consumer courts. Why this figure is important? Remember that majority of the cases are being filed against MBBS doctors. The number of cases against Ayush doctors is bare minimal. Against dentists is bare minimal. So effectively, 95%, 99% cases are against MBBS doctors. And 80% of these are related to hospitals and inpatient care, not so much to individual clinics. Which means if we look at 80% of this figure, it is 45,000. And total number of hospitals in the country is 69,264 as of 31st December 2023. What does this mean? This means nearly 0.662 per hospital is a case which is either pending. So at any given time, or at least in 2 years, there is one case which is either pending or has been decided against or for the hospital in consumer courts for medical negligence. The difference in the number of cases being filed is exorbitantly large compared to the 113 cases we had for over 20 years. So effectively, this number is exponentially growing. This is my point. And we are not including in this the number of out-of-court settlements. So many doctors come to me, Doctor Sahab, wo problem hui thi, IV lagaya tha, the finger got amputated, the gangrene occurred and finger was amputated, and we gave them 1.5 lakh. Now they are asking for 20 lakhs and they have gone to consumer court. These kind of out-of-court settlements happen daily, and they happen across India, and the number of these is much more than the number of cases which have been decided in a year by courts. Again, conservatively, if we take the figure as 2 times, then the total number of consumer disputes, whether in court or decided by court or settled out of court, works out to be nearly 1 lakh. And if we again look at the number of hospitals in the country, it is 69,000 only. So more than one case, 1.5 case, where either out of court settlement has been done, or case is still pending in court, or a dispute has been decided for a hospital. So all hospitals effectively are facing litigation, are facing disputes, are facing allegations of negligence, and this number is exponentially increasing. This is my basic issue. And it is increasing at a very rapid pace. We do not have the data. This is what I have told you is some degree estimation, some degree fact. We have some facts from my previous work which I have done. But if you look at the graph, if somebody were to draw a graph, this is exponential growth. And part of this is because there is a new formula to calculate the compensation which was introduced in Kunal Saha judgment. Earlier, it used to be a multiplier method, which was straightforward for roadside accident, and the compensation amounts were curtailed. With this new formula, the compensations are going haywire. Even in a government hospital in 2015, a total of 2,28,87,921 was awarded in the case of V. Krishna Kumar versus State of Tamil Nadu for not picking up ROP. And the pediatricians were penalized for this. The pecuniary jurisdiction in 1986 and in 2019 is now very different. In CPA 1986, if a compensation was asked for up to 20 lakhs, then it would come in district fora. Between 20 lakhs to 1 CR, it would go to State Commission. And more than 1 CR, it would go to National Consumer Dispute Redressal Commission. In 2019, what has happened is the change of pecuniary jurisdiction the terminology has changed. It is no longer what is the compensation which is being asked. Now it is whether the patient has paid more than 50 lakhs for the services. Now, which gynecologist has charged 50 lakhs for infertility or for cesarean or for hysterectomy? None. Maybe a few cases of liver transplant would cost more than this. But otherwise, all cases of allegations of medical negligence by this pecuniary jurisdiction will now come to District Commission. My problem with District Commission is District Commissions are not manned by proper judicially educated officers. This is dispensation. This is political dispensation which decides who is to sit in District Commission, and the society at large does not expect justice from District Commission. It is expected that when the matter goes to State Commission and National Commission, the matter will be decided on judicial principles. So if the person has paid between 50 lakh and 2 crores, then under those circumstances only the matter will go to State Commission. And if and only if he has paid more than 2 crores, can the case go to National Commission. So effectively, henceforth, do not expect any case to be filed in National Commission. 99% of the cases will be in district commissions, and few of very rare will go to State Commission. The problem is there is no upper limit on what compensation has been asked for. If a person has paid 500 rupees consultation and he wants 200 crores to be awarded to him, all he has to do is he does not even need to file a court fee. All he needs to do is sit in his bedroom, go on his laptop and file an e-complaint against me in the consumer court. And like pizza is delivered, similarly, probably in the next few years, we'll expect compensation to be delivered to him in the next 30 minutes. Look at the way quantum of compensation has been rising. I have already shown you the number of cases increasing, but look at the quantum of compensation also increasing. Very prominent case, 1993. This was V. Chandrasekhar. He was the table tennis champion of India. And he was operated in Apollo hospitals and he was awarded 17,37,000 in 1993. And it was considered exorbitant. After that, we had Spring Meadows Hospital case in 97, again around 17-18 lakhs was awarded. Then came Prashant Dhanaka, this was in 2009, which breached the 1 CR barrier. Then Kunal Saha's judgment, of course, which came to 11.6 crores. And after that, 76 lakhs, 73 lakhs, 80 lakhs, 1 crore, 73 lakhs, 9 crore, 85 lakhs. This has been awarded in a charitable hospital case, which did some cataract surgeries in a charitable rate in Tamil Nadu. And the Sessions Court there awarded 9 crore 85 lakhs in this case. What I mean to say is there is a trickle-down effect. And if the Supreme Court can award 11.6 crores, obviously we are no less. So we can also award compensations in crores. And there are multiple judgments of more than 1 crore, which have come in the recent years. In fact, as late as 2023, we have had this in National Consumer Dispute Redressal Commission, 1.62 crores, Parikshit Dalal versus Santosh Hospital. I will touch this case later also. Similarly, Priyanka Tandon versus Bhatia Global Hospital, 1.5 CR. What I mean to say is, crores is rolling off the tongues of our district, state, National Consumer Dispute Redressal Commissions, as if it is simple saliva. It's so easy. I don't know, maybe in Mumbai, Chandigarh, we will find it very difficult for anyone to pay a compensation of 1 CR or 1.5 CR the way they have been asking. The people have been asking for 200 crores also, but this is what is being awarded. And why every doctor needs to be careful? No one is immune. Doctors from government, ESI, charitable, ESH, army hospitals, and private sector. Everybody is covered. No limit on what compensation can be asked for. Interest on compensation may actually be more than the compensation, and award may be more than the compensation which has been demanded. Patient has asked for, I think, 3,200, and the court, NCDRC, has awarded 5 lakhs in that case. So there is no rationale in the way things are moving. And now in 2019 judgment, the CPA, they have also mentioned very clearly that you can go and appeal only and only if you deposit 50% of the compensation awarded. Very clearly meaning a patient can go and appeal if no compensation is awarded. But a doctor, if he has to go and appeal, he has to deposit 50% of the compensation first. This could easily have been extended to whatever amount the patient is asking, let him deposit 50% and then go and appeal. But no, after all, that would be against public good. Number 2, earlier in Supreme Court, when cases used to be taken, from National Consumer Dispute Redressal Commission, Supreme Court would say we will accept only cases on where substantial question of law is involved, not on facts. So here, now even NCDRC, you cannot make an appeal unless there is a substantial question of law involved, not simply that these are the facts. District Forum has given a judgment which is against common sense. A state commission has not agreed with our arguments. So kindly hear our arguments. No, you can't go to NCDRC on these grounds. You have to demonstrate that there has been a question of law which has involved, and then they have to decide. Compassionate compensation in Consumer Dispute Redressal Commission is creating the most heartburn. No negligence. The court says no negligence, but the patient is poor and has suffered a loss, and the doctor is insured, so please give him some money. This is a dispensation which for the doctor is very horrendous, because they have argued and defended themselves in courts for 7, 10 years. And then they are told, okay, you are not negligent, but you have to pay a compensation. Similarly, treating VIPs is becoming very dangerous now. And I can give you examples and examples, but then the worst part is cases in Consumer Protection Act can be filed along with case or a complaint filed in other areas, which may be judicial or quasi-judicial. So what happens today? A patient first files a complaint against a doctor to the employer. That employer may be the government, that employer may be a private hospital. Then he also files to the State Medical Council. He also makes a police complaint. This is all alongside the consumer court case which he has filed. Then he files the complaint to the Chief Minister, to the Prime Minister. Complaint to NABH, JCI, the accrediting agencies, asking them why they have accredited this hospital which is so negligent. And you have to defend yourself under each authority simultaneously on same fact, same matter, same opponents. Complaint is filed to ECHS, CGHS, Ayushman Bharat. Again, simultaneously in the consumer court, simultaneously in the criminal thing, and also to these authorities. Similarly, complaint to NRI cell, Women's cell, SC/ST Commission. Complaint recently was filed under Juvenile Justice Act. Under Juvenile Justice Act, if convicted, even for 304 is 2 years imprisonment. Juvenile justice, there is 7 years imprisonment. Complaint under POSCO Act. National and State Human Rights Commission, High Court and Supreme Court under Article 226 and 32. And all this is besides the Supreme Court of WhatsApp justice and the media trial, which also the doctors face. So my point is, if you have to hold us accountable, hold us accountable. Have one tribunal where I can defend myself, has one appellate body where I go in appeal in case I find I have not been given justice. But this thing that there are 14, 15 places where a complaint is filed and I have to defend myself there for whatever reason. If NABH takes back my accreditation, or if JCI takes back my accreditation, it is going to affect my bottom line. I have to defend myself there. If a complaint is filed with the Chief Minister and he marks it to the DHS forms a board, I have to defend myself before the board. All this is simultaneously while I'm defending myself before the police, before the CPA, before the consumer courts. This is what I find is the worst part of Consumer Protection Act, and which is something because of which we should be removed from consumer protection. The only thing good is a patient cannot file a case in civil court for compensation as well as consumer court, and this also is a judicial decision from 1998. This has nothing to do with the law. All other citizens in the country have this legal principle which protects them, which says very clearly that if you are being tried in any court against any opponent on same facts, you cannot be tried in two courts on the same issue for the same facts. आपने आज मर्डर किया है, आपका कोई केस डिसाइड हुआ है, you have been exonerated. It is not something which you can take to the opposite party can take to another court and say, no, fine, now you re-look at this matter in a parallel fashion. This is something which cannot be. This is called issue estoppel or res judicata. But then doctors in India, especially modern scientific medicine doctors in India, are probably not citizens. And that is the basic problem. Under CPA 2019, we now have e-filing. I already told you, like you're ordering a pizza, that way a complaint can be filed. Video conferencing, district commissions filing in 99.9% cases. Deemed admissibility of the complaint after 21 days of filing. Person has woken up, he has made a complaint online. If the court does not decide one way or the other, it is deemed admitted. And after that, you have to defend yourself. Then earlier it used to be where you have operated, that used to be considered the place where the case would be filed. The cause of action has occurred in Mumbai. The case has to be filed in Mumbai. Today, if I go from Chandigarh to Mumbai and want to sue the doctor there, I will come back to Chandigarh or maybe even to a smaller district, let us say Fazilka, so that the doctor to defend himself has to travel all that area for every case. This is a problem which is going to find more and more doctors trapped within it. And no fee for services paid up to 5 lakhs. 5 lakhs, how many doctors charge 5 lakhs for their services? No penalty for frivolous complaint. Yes, 1986 had a penalty for frivolous complaint. It was an exorbitant amount of 10,000 rupees. Even that now has been done away with. And now exorbitant compensations, as I said, have been awarded. Remember, if you're fighting a case and you are harassed and you think the case is causing distress to my family, or your committing suicide will not end the case. The case will continue, and substitution of legal heir or representative as party to complaint in event of death of complainant or opposite party was there in 1986 CPA 2002 amendment, plus in CPA 2019. This is also mentioned very, very clearly. So death is not an escape. What was the reason on 14th of May that Supreme Court decided that advocates should not be covered within the purview of Consumer Protection Act was? They said advocates are providing contract of personal service. This contract of personal service and contract for personal services is what was decided by VP Shantan judgment, where they said the contract of personal service is a master-servant relationship. Master says you do this, so that is not, your service is not within the purview of CPA. Whereas doctors, they provide, they and their patients have a contract for services, which means patient comes to you with abdominal pain, you decide how you want to treat, what you wish to do. So this is not a contract of personal service. My problem is 2008 Samira Kohli versus Prabha Manchanda judgment. You have said very clearly that once the patient is under anesthesia, you have taken consent for one procedure, you want to do another procedure, which you think is in the interest of the patient. Now, this judgment tells me very clearly, I cannot proceed. I have to let the patient come out of anesthesia, give a consent separately for the second procedure, and then only go ahead with the second procedure. Is this not master-servant relationship? I can do only what my patient has asked me to do. I cannot do anything which I think is in the interest of the patient. So this is a master-servant relationship, which makes it a contract of personal service. And if it is a contract of personal service, like advocates, we should have been out of CPA. Mediation has been added in 2019. E-commerce will be included. So all these online consults and all will also come in. There is a concept of unfair contract which has been included, which I feel will create more and more problems later. But this is because consent per se is a contract. And we do not realize it that it is a contract, which is where tomorrow the patient will turn up and say that this is an unfair contract. and which is why the consent should not be considered valid. Many reasons why doctors should not be within the purview of Consumer Protection Act. We were hoping and praying that this judgment of the advocates being in within the purview of this CPA would give us some kind of advantage. But the only escape valve they have given is they have said that the Honorable Supreme Court should create a larger bench than the 3-judge bench, and that should hear the VP Shanta in judgment again. We had gone to Bombay High Court first in 2021 against the inclusion of medical services within the purview of Consumer Protection Act 2019. This was the case of Medicos Legal Action Group MLAG versus Union of India. We lost our case there, and we went in SLP to Supreme Court, and it did not admit our SLP under Article 136, which is the power given to the Supreme Court to hear such cases. So it was on a technical ground. They have not heard the arguments in Supreme Court, and we had anyway made only one single point argument that it was not the legislative intent to include doctors within the purview of Consumer Protection Act. Ramvilas Paswanji had mentioned very, very clearly when CPA 2019 was being formulated that doctors would be dropped, and all the proceedings of the Lok Sabha and Rajya Sabha was placed by us there. We did not include the other issues because we had that time considered, and the legal view was the other organizations will have a chance to put up their arguments, and in those arguments, the other points like the consent of personal service and the consent for personal service will be covered. But now, anyway, we have already made a representation to Chief Justice and to Ministry of Law and Justice to create this 5-judge bench, and Medicos Legal Action Group has asked for an opportunity to present our arguments. We are preparing our case, and hopefully, as and when this happens, we will be in court again against Consumer Protection Act. Ideally, we have given government representation that there should be a medical injury compensation and liability bill, which should be passed. So we have given an alternative how this compensation and accountability can go hand in hand without creating a hurdle for the doctor-patient relationship. But then they have a lot of ivory tower experts whom we have not been able to convince, even though they are doctors, because everybody in their list of experts is only from major institutions, whereas on ground, 70% of the healthcare in India is provided by small and medium healthcare establishments, which has no representation either in National Medical Commission or in Niti Aayog or wherever. So effectively, unless and until something is done to change this representation, it is going to be difficult, but we are going to try. Thank you so very much. I hope I haven't overshot my time.
No, sir. I think you did it in 30 minutes, I think. Thank you so much for that elaborate explanation about the CPA from the beginning till today. And I think whatever is being, fought for doctors in the coming years, let's hope that something will come more friendly towards the doctors, health professionals. And I think, would you like to say something?
Yes, madam.
Dr. Madhu?
Yeah, Dr. Gorak and Dr. Meena Samant. Yeah, please go.
Suman ma'am also.
Hello, good
Yeah,
evening.
Gorak,
Sir, it
please.
was very nice lecture, and it was actually thought-provoking and very great. And you have given a very two important clear messages that what the organization should do in coming short period to work for against this Consumer Protection Act. And second very important thing, you raised a very great point of representation of the small nursing homes. And I think the organizations like Foxy or even IMA, they again have to do something about it. And even the lecture or the points what you made, many of the points they really we all as a member are unaware of. And thank you very much, Dr. Sneha Madam, Dr. Suyoga Madam, and Dr. Monica Madam for inviting Sir, because this was really a thought-provoking talk. And many things they will be now taken to the organization. And I personally, as the chairman of PNDT Committee of Maharashtra State, I will try to do something to gather representation of the small nursing in this case, and we'll get back to you, sir. Thank
I
Suman
think
ma'am.
basically a lot of small nursing homes are disappearing now because of this corporate culture, and just mediocre hospitals are surviving. At least I see in Telangana area.
Same,
Ma'am,
same.
but the problem is we do not have data. Let us look at the data. Where is the data? We are not collecting that data. And when we are talking of small to larger nursing home conversion, this is happening in tier 1 cities.
Yeah.
When we are looking at the tier 2, tier 3 cities, the situation is very different. And sometimes when I'm seeing even in places like Chandigarh, we used to have 28 nursing homes at one time. We have 10 nursing homes today.
Yeah.
So it is, the problem is the small and medium healthcare establishments are disappearing.
Correct.
And we do not have any representation either in National Medical Commission or to the government. Even everywhere it is institutional.
Yeah.
Director JIPMER, Director All India Institute, Director PGI, they are in their ivory towers. They have no idea what is happening on the ground.
Absolutely, sir. Agree,
Agree.
sir. Absolutely agree, sir. And you have raised this very important point, and that's why I said here there are so many leaders of the organization of the Foxy and IMA. So it is urged to all that the sir has raised a very great point, and we all should work on this.
But
Thank
we
you, sir.
have private hospitals, organizations also there, but they also don't come forward with their.
Ma'am, they are dominated by the larger players.
Yes.
Yes, that's
And
the reason, sir.
And
You
madam, another problem is those small hospitals or medium hospitals are run by the doctors, whereas the corporate hospitals are run by non-doctors who
Yeah.
absolutely don't suffer nor do have the ideas of what problems we are facing.
Absolutely. They have nothing to do with the
I think,
patient.
yes, Gorak.
They have nothing to do with the patient as such, because they
Don't
are
see
their clients and money giving machines are there. No? That's why that is a
bottom
problem.
line, that is, they are looking at the
Exactly.
bottom line.
Absolutely.
Exactly
But
this point I wanted to say that, they, because of these corporate hospitals, even the humanity aspect of the doctors, people are losing that aspect of doctors. They are taking it as a business and not a profession. So I think we echo the
Suman
same.
ma'am.
Suman, yes.
Yes, ma'am.
Thank you.
Ma'am, you're not audible.
You are not audible. Look in front, I think some issue with the audio.
Not yet?
Not
No.
yet, ma'am.
Now you can hear, we can hear.
Yes, ma'am.
You can?
Yes.
Yes, ma'am. Now it
Let me
is
my
audible.
speaker. Let me see the speaker. Yeah,
No,
it's
you are
full.
correct hai.
So I wanted to thank Sneha madam for giving me this opportunity, and I wish her good luck for the coming elections. And I'm really overwhelmed. Neeraj Nagpal sir, really, you have walked your talk and made it so clear to understand this CPA, and this out of court settlement is very rapid these days, and that is of not much benefit. What they think that if I go out of court, I'll be
Useless.
more wiser. It is not that. They try to blackmail,
Exploit you.
exploit. And
In
one of my
conclusion,
friends is
madam,
suffering this. Sorry, one of my friends, she had some problem, and her lawyer advised her to go out of. She went there. Earlier, it was compensation of 2 lakhs, and now it is 3 lakhs. Now they have made it 1 crore.
So every
I
data,
think, Suman, we are not
yeah.
getting your voice, Suman.
I think
We're
she's
not getting
talking
your
about
voice.
out-of-court
Yeah.
settlement, which is
Yeah,
there,
yeah.
and
Yes, yes.
that is leading to blackmailing.
Yeah.
Probably out-of-court settlement also you should do
This
legally.
is a real truth story I'm telling about my friend. I don't want to take her name,
No,
but
no.
she was in trouble. So she took help of her lawyer. And after listening to her story and everything, they said you go for out of court settlement. But out of court settlement, earlier it was 2 lakhs or 3 lakhs. And then they were again bargaining. Now it has come to 1 crore. And the case has moved from civil court to now Supreme Court or something like that. So they are in big mess now. So it should not be, it always go to the real, जो बोलते हैं ना सही line पे जाओ, instead of going here.
नहीं, out-of-court settlement करे तो भी you should do it legally.
Legally written, everything written.
And
कि आगे
the term we use is it should be settlement in court.
In court, yes, exactly.
Either you go to Lok Adalat
Yeah.
or you in Consumer Protection Act 2019, now there is a provision for mediation.
Yes.
You go to
Yes, sir.
court in CPA 2019 and tell the court that we are going for mediation. They will refer you to a mediation cell and you settle the amount there. Once it is decided by Lok Adalat or a mediation cell, after that there is no appeal.
Correct.
Then tomorrow the patient party cannot turn around and say ki, no, I need 200 crores now.
Yes, sir. Actually, sir, what you told now, that provision many of our
Colleagues don't know.
know, and that's why they try for out of court settlement. That is a problem,
Yes.
sir.
But they never try to consult at least some, members, those who have some knowledge. At least
yeah,
they can guide
really,
them.
na, they go. They don't go to the correct medical legal expert. They go to somewhere,
Yeah.
and then they are trapped.
I know. True.
So do we have Meena ma'am, Saman madam here for her comments?
No. I think she messaged me that because of some network issues, she has to leave. So
Yes.
I think it was a wonderful presentation, Neeraj sir, and really it was thought-provoking. I'm sure that if you continue this discussion, it will go on and on. Madam Jamna Devi will also agree to me. Maybe sometime later, maybe we can just have sir's talk as separate with the interactive session. So thank you so much, sir, for your precious presentation as well as your presence. I thank all the faculties, and Monica, over to you for your formal vote of thanks. Thank you so much, Chairperson, all the lovely people. Also contributing so much to this discussion. Thank you so much.
And wish you good luck, Sneha.
Yes, best of luck, ma'am, for your election.
Thank you, sir. Thank you so much.
All the very best in your next election and your future endeavors.
Thank you, dear. Thank you so much. Thank you, everyone.
Best wishes, Neha madam, and thank you Benchmark Series Episode 7 for conducting this wonderful webinar on medico-legal aspects, which had stalwart speakers and great chairpersons. I thank all faculty for participating wholeheartedly. I also thank my co-coordinator, Dr. Monica Umbardan, and thank you again, Sneha ma'am, for the opportunity. And hope we keep connected through Benchmark and keep doing wonderful programs. Thank you so much. Have a good night. Thank you.
Thank you, sir.
Thank you, all the faculty members.
Thank you, everybody joining. In spite of your busy schedule, I have already welcomed all of you at the inauguration itself.